Assalamualaikum warahmatullahi wabarakatuh. Good morning, everyone. On this occasion, I will introduce myself. My name is Suherman. I'm from Law Faculty, UPN Veteran Jakarta. I will present my article with the title The COVID Disaster-19 as Post-Major in the Business Agreement in Indonesia. I will share screen. Introduction. In middle of March, the Indonesian government announced that the spread of COVID-19 was a national disaster. Indonesia also make policies for their citizens to carry out activities at home, such as studying at home, working at home, and worshiping at home, are carried out in the context of social distancing to break the chain of the spread of COVID-19. There are many countries also make policies for lockdown policy. However, Indonesia government make the policy by implementing the large-scale social restriction or PSBB in several regions in Indonesia. The government policy has a high impact on the economy. There are many layoffs because their companies stop producing. And many factories were closed, so that many companies were unable to carry out their obligation to contract that they have signed by the other parties. The President of the Republic Indonesia on April 13, year 2020 has signed Presidential Decree number 12 of year 2020 concerning the determination of the coronavirus or COVID-19 as national disaster. So, many companies in Indonesia are unable to carry out their obligation and will terminate their contract unilaterally on the basis of national disaster as a result of the coronavirus or COVID-19 as a post measure. However, whether the coronavirus or COVID-19 is a post measure in business contract in Indonesia. Next, research methodology. This research method use empirical normative methods. Normative legal research is also called doctrinal law research. Empirical legal research is a review as independent or causal variable, which cause influence and a consequence on various aspects of social life. In addition to using juridical normative, empirical research is also needed, including field research, is also needed to find out some company affected by the COVID-19 disaster on contract that have been signed and able to carry out their obligations, so whether it can be said that this is a post measure. Discussion regarding whether the coronavirus COVID-19 is a post measure in business contract in Indonesia, so it is necessary to analyze the elements of post measure with the condition of contract implementation during the COVID-19 pandemic in Indonesia. The first element, the occurrence of circumstance or events beyond the will, ability, or control of the parties. Based on the objective theory, states that it is completely impossible for the debtor to perform the performance to the creditor. The objective measure is based on a normal measure in such circumstance whether one party can perform its obligation or not to the other party. So, if according to this theory, the objective measure is according to the normal size in carrying out the achievement. So that will show that with the current pandemic condition, it can be said that conditions are not normal for company to run their business and are also not carry out and are also not normal to carry out their obligation. With the condition and objective theory above, the first element is fulfilled in a state of force majeure. The second element, causing harm to the parties or one of the parties. In Negari's theory, according to J.L.L. Wary, explained that the theory of risk, the parts debtor must be punished to pay compensation if it cannot prove that the obstruction of achievement arises from appropriate circumstance. And the third element, the occurrence of the event caused by the parties to delay, obstruct, or not carry out the achievement. According to the subject theory, that the relative impossibility of the debtor to fulfill its achievement, this subjective measure is based on the situation of the debtor by relating the sacrifice that must be received by the debtor if he has not performed this achievement to carry out his obligation to creditor. The fourth element, the party have made such effort to avoid the incident. What can prevent and avoid this disaster? In the sense, the COVID cannot be eliminated quickly, but it is necessary to find a vaccine first, which require a long period of time, between 1 year or more. In fact, business actors must continue to run and operate their business because if they don't operate for 1 day, it will cause enormous loss for the company. 5 elements. The incident effect, the implementation of the agreement, according to risk theory, risk is closely related to uncertainty. Although risk and uncertainty are different. According to Robinson and Berry, uncertainty is the sign of an event that cannot be measured by the contracting party, so that the absence of certainty will force a risk. The COVID-19 pandemic is an event that cannot be measured by the parties when they sign the contract, so that the pandemic event can affect a contract made by the parties. Based on the analysis of the element of force majeure above, all of the above elements have been fulfilled and have also been supported by the theory about force majeure. So the COVID-19 pandemic has created a force majeure in business contract in Indonesia. However, the force majeure event is either absolute or relative force majeure. Again, the research will provide the following analysis. The first, absolute force majeure is a condition where an achievement cannot be carried out because of the earthquake and tsunami which result in the destruction of objects or goods. The second, meanwhile, relative force majeure is a condition that causes the debtor to be able to carry out his achievement or to temporarily suspend his performance until it's possible to fulfill the achievement. Judging From the two types of force majeure, the authors are more inclined towards a relative force majeure because the COVID-19 pandemic is effective to end after the discovery of a vaccine from the coronavirus at the end of 2020. It is hoped that conditions will return to normal, so that this situation is only temporary. After that, one of the party experiencing force majeure is effective to be able to run its business again and able to carry out its obligation back to the creditor. This is aligned with the opinion of Professor Ninjo, time of COVID-19, force majeure event and its settlement draw arbitration, state that the COVID-19 phenomena can be categorized as one of the cases of force majeure, although it is not an absolute force majeure, but rather a subjective force majeure or relative. And then our conclusion. Based on the analysis of the above researches, the COVID-19 pandemic that occurred in Indonesia, based on the analysis of the element of the force majeure, which consisted of the occurrence of circumstance or event beyond the will, ability, or control of the parties, causing losses to the parties, or one of the parties, the occurrence of this event causing delay, obstruction, or performance of the parties not being carried out, the party have made such effort to avoid the event. The incident effect, the implementation of the agreement, then all the elements of force majeure have been fulfilled so that the COVID-19 pandemic is a force majeure for business contract in Indonesia. However, the force majeure is temporary so that after the end of the COVID-19 pandemic, the contract can be continued. The decision to continue or not an agreement due to force majeure must be resolved from the consensus of the parties. Thank you for my presentation.